I'm going to let the panelists each introduce themselves, but I want to say thank you so very much for joining us.
Shall I begin? I think I'm first up. My name is David Sonenshein. I'm an emeritus professor of litigation at Temple Law School in Philadelphia. I've been teaching civil procedure, among other things, for about 40 years, including injunctions. And prior to that, I practiced law in Boston doing civil litigation for 8 years before beginning my teaching career.
Your Honor, may I proceed? See, I'm a judge, so I have to. My name is Sozi Tulante. I'm a partner at Dechert. This is my second stint at Dechert. I've had a varied career as an adjunct professor at University of Pennsylvania, as well as a city solicitor for the city of Philadelphia, where I was subject to a lot of injunctions on behalf of my client, but also brought some, and I'm excited to be here.
Good morning. My name is Mark Kearney. I'm a judge, a federal trial judge in the United States District Court for the Eastern District of Pennsylvania. I was nominated by President Obama, and I'm now almost through my 11th year in serving the court and serving the citizens of the Eastern District of Pennsylvania. I have the privilege of sitting in Philadelphia, Delaware, and in the Virgin Islands. And you can imagine we see more and more preliminary injunctions every day. So I'm pleased to be with this panel and happy to answer any questions.
Yeah, I think David will kick us off, but before he does, we wanted to give some statistical background, thanks to my former associate and my future clerk for Judge Kearney, Mackey. We noted that injunctions are obviously in the news quite a bit, and by measure of comparison, from July to December 2024, just looking up the word injunction in the New York Times, there are 60 mentions, articles. In January to June 2025, it's 200. Same thing with Inquirer, it's 15 in the earlier period and 45. And the Wall Street Journal, Washington Post, there were 30 articles related to injunctions, and now they're about 100 or over 100 in the later period. So as you can tell, the coverage of injunctions has tripled quite a bit and doesn't really see any signs of slowing down. And so we're hoping as you're writing more about injunctions, we can give you some context. And no better way than to kind of get educated by Professor Sonenshein to talk about what preliminary injunctions are and what they're not.
Thank you, Sozi. I'm delighted to be here, of course, as I think we all are. Interestingly, I'm looking at the statistics that Sozi's colleague and Judge Kearney's future clerk gathered for us, did a wonderful job, of course. And it's interesting that the coverage in these major press outlets of injunctions really tracks the fact that toward the end of the Biden administration, a lot of conservative groups were bringing injunctions against his executive orders. And this is mentioned, by the way, by the Supreme Court in its recent opinion. And then, of course, starting in January, a lot of more liberal groups bringing injunction actions against executive orders from President Trump. So it's a thing that is, it's not in a sense, it was partisan and when it's done, but it's been done by everybody in the last year or two, because I think reflecting some of the partisanship in the United States. Interestingly, and therefore, I think we've suddenly seen an interest in preliminary injunctions. I will tell you, and I'm sure Sozi would agree, most people aren't a lot of news coverage people when you seek a temporary restraining order. And actually, there would be no people ordinarily in that situation, or a preliminary injunction. It's usually not a hot issue, but now it's become bound up with policy, with big issues, et cetera, et cetera. Preliminary injunction, I think the important thing we have to appreciate first is, although, as we'll see in a moment, the district judge, or as I see them very often, state court trial judges as well, are not considering or deciding the merits of the case. Although one of the standards for granting temporary or preliminary relief is the judge's, thumbnail quick view of, is the plaintiff, the party seeking the injunction, likely to win on the merits? Not a decision on the merits, very different matter. But that's an important point. that when you're reporting on an injunction or a restraining order or injunction being granted, that it has temporary importance. It was not a final judgment. It is time limited, et cetera, et cetera. And eventually, once we get into the merits of the case, we may have a completely different verdict than what you've seen in the injunction order. And I think we have to appreciate a couple things. First, there's something called a temporary restraining order, which you've heard about, I'm sure. And that is a little bit different from a preliminary injunction. They are both, in fairness, preliminary, based on the pleadings, sometimes some documents, sometimes some affidavits for the injunction, even sometimes some live testimony, but they are temporary and emergency type orders, particularly the temporary restraining order. One big difference is this: a temporary restraining order, very short term emergency order, is often given ex parte, a Latin phrase which many of you might know, meaning done without notice to the other side. Now, most of the time, as you appreciate, legal proceedings require notice to both sides. Both sides have an opportunity to be heard as a matter of due process. And I think we're all pretty familiar with that. The theory of the temporary restraining order, and I remember getting a fair number of them in Boston in the Superior Court back about 40 years ago. I don't think they're as easy to get today, by the way. They were pretty free and easy about it in those days. But frankly, I would come into the courtroom. Was not on a list, go up to the clerk. The clerk would say, "What have you got?" "I want a TRO," and describe the case. And he would take me, in that time issued day, it was a he, as a matter of fact, back into the judge's chambers. The judge was having a bagel and cream cheese, and reading the Boston Globe sports page, and wasn't no robe, ready for court about 9:30, and they'd say, "What do you got?" And we would describe the case, and a temporary restraining order would, maybe should, I don't know, be issued. And then we'd give notice to the other side, and within 5 days have a hearing, so that both sides had the opportunity to do it. There was no one there. We were in chambers. And so, again, that really highlights the issue of ex parte, that the other side wasn't notified. The theory, by the way, behind that is there isn't time to notify the other side before the harm would be done in the absence of the restraining order. Or if the other side were given notice, it might immediately go out and do something that would make the remedy you're seeking in the end impossible. And so that was the thinking behind allowing those very, very, and the word is temporary, restraining orders to be issued. Preliminary injunction involves notice to both sides. It involves both sides being heard. It involves, again, both sides submitting documents to the court, perhaps affidavits, declarations. Sometimes the court might want to hear live witnesses. That has been done, so that the court has a much more robust view of what's going on in the case, what's likely to happen, and then be able to weigh a number of elements to be able to see if the injunction, now a preliminary injunction, which again is time limited, but usually there's a lot more time involved before we get to the merits, obviously. And those four issues are the following, those four elements that the motion judge has to think about. One, I've already mentioned, the likelihood of success on the merits on behalf of the plaintiff. That is, the plaintiff, ordinarily the person seeking the injunction, would have to demonstrate that if and when this case goes to trial, they have a very good chance of succeeding. Thinking, obviously, is that the plaintiff has no chance. Why would I bother to enjoin anything the defendant's doing, which may be completely appropriate and not going to be subject to any violation of law? And so why stop them from doing what they're doing? The second issue is, will there be irreparable harm? And by the way, I think different judges might weigh these a little bit differently. I happen to think, in my mind, and Judge Kearney can certainly speak for himself on this, I think the irreparable harm has always struck me as the most significant issue here. The thinking being, if we don't put a hold on this universe right now, something awful, either financial, physical, policy-wise, et cetera, will happen to the people the plaintiff lawyer is representing. And so the question is, if we wait for trial, will the harm already be done and will no longer be able to be remedied by simple monetary damages? The harm's already done. You can think about a voting rights case. If a person's denied the right to vote, by the time the case would be heard, the election's over, as an example, Third, and this to me is very significant as well, is what's called the balance of hardships. That is, the district judge, we'll talk about federal court for the moment, a state judge would do the same, has to weigh, look, I understand there's some harm that will befall the plaintiffs, but if I enjoin, that is stop, right, put a hold on the defendant's activities related to what's going on in this lawsuit, will they suffer a greater harm? Will they have to go out of business if it were a commercial case, et cetera, et cetera. And so again, there's an issue now of how serious is the harm? Is it truly irreparable? At the same time, it could be irreparable to the defendant, and put them in a situation where they are harmed at least as much or even more than the harm that could be done to the plaintiff in the absence of granting the injunction. And then finally, and again, in the kinds of cases we talk about and you report on a lot, there's a public interest issue as well. I mean, clearly in the executive order cases in both administrations, these are massively significant public interest questions, whether it's immigration or whatever it might be. And the court would then have the ability, which it doesn't ordinarily do in regular situations, consider what would be the impact on society, economic implications, policy, et cetera, of doing this. That is, if I can be sort of blunt, is it good for the country? Is it good for the people of the United States or the people of Massachusetts, in my experience, when I was practicing, to do this? Or may there be some, in a sense, irreparable harm to the public by doing this? You can imagine, for example, cases involving people trying to enjoin press people from doing things. You can imagine there's a major public interest in do we stop that or put a hold on it or limit it or anything else. Notice two other things I'll mention, and then I'll stop for a minute. Often, the court may require in the issue to ameliorate in the balance of hardships equation harm to the defendant that the plaintiff put up a bond. That is, put up a bond. There'll be a premium that is paid by the plaintiffs to protect the defendant from harm that might occur if the injunction is granted. And again, to avoid tremendous hardship to the defendant in the case of the injunction was improvidently granted. And that makes some sense, although sometimes plaintiffs are unable, depends on who the plaintiffs are, to be able to afford a bond, as we can appreciate. And of course, both sides will get notice. And of course, there will be notice required to be given to the defendant by the plaintiff. And ordinarily, the court will schedule a hearing, and there will be arguments back and forth. And the court may or may not, this is important for you to know if you're covering this, may or may not issue an injunction or deny it at the very moment the lawyers finish speaking. The judge may want to consider it. And in fact, a thoughtful judge would say, well, let me think about this. Let me read the briefs. Let me see what's going on here before doing it. Big thing, I think I'll just finish with, you're reporting, things are happening quickly. You're on deadlines. I can appreciate that. When I lived in Chicago, I had many friends at both major newspapers. I'm aware of their situations. But don't be taken in by what lawyers say when they come out of the courtroom. Oh, well, this is a tremendous victory, et cetera, et cetera, et cetera. It's only preliminary. It's only preliminary. And the case could well end up a very different way. In fact, in many cases, it will be settled. in many ways. Certainly commercial cases would certainly ordinarily be settled. So bear that in mind. And you really want to be careful in your reporting that this is a district judge not deciding on the merits per se, but just putting a temporary hold on things so the judge can get a longer look. There may be discovery, et cetera, that will enlighten everybody as to what the real issues are and what the merits really would merit, if I could say that. But those to me are the simple legal issues involved. We're going to turn things over now to my colleague, to Sozi, who has, of course, appeared many times, for and against, I'm sure, given his experience, the issuance of an injunction, and to talk about what a lawyer's thinking about when he or she gets ready to go into court and then appears and makes arguments. So, Sozi?
Yeah, and I'll be brief. Try to cover a couple of things to remember, and I think Professor Sonenshein mentioned that is when we think of injunctions, we think of often when you're reporting executive orders, issues that have broad implications, often across the country. But most injunctions actually are your classic, often commercial cases. In IP, someone is using your patent, you want to stop that. Or you have a former employee who has a trade secret they shouldn't have, and you need to sort of stop that from being disseminated, or they're going to go work for a competitor despite a valid non-compete. And if you don't stop that, then you have substantial harm. A couple other things too, again, to remind you, is that a lot of the injunctive relief that's sought is in state court. While, Judge Kearney and the district courts obviously get a lot of the attention, your basic injunctions, if there is going to be, we always say, like, there's a church that's about to be, torn down, and you need, that it wasn't properly done. You need to stop that right away. Often that will be in state court. So that's another example. A couple of things too is that the burden is really high on the plaintiff, right? You're asking the judge to decide on an expedited basis without all the relevant facts and predicting whether you're right in the merits. It's a likelihood you could end up being wrong. So as the Supreme Court has recognized repeatedly, it's an extraordinary remedy. And so the question is, if you're a plaintiff, and I've been on both sides, how do you do this, right? You want to show urgency. Your Honor, if you don't take this action now, it will be too late. And so often that's done by declarations, because they show the human component of it, and that's put in the record. You often need expert testimony. Again, even though you're not at the merits, you need expert testimony, empirical data to be able to persuade a Judge Kearney that, Your Honor, this is not just me saying this. We've gone through the work of amassing information for you to rely on. And then beyond that, it depends on judges, but some judges want a hearing. Now, we're not talking about a full-blown 3-week trial, but it's a mini trial, maybe over a day. You present evidence. The rules of evidence are a little bit more relaxed. So no jury. You're able to persuade the judge, like, there's a record on which to base whether there's reparable harm, what the balance of harms look like. And then from a defendant's perspective, how do you defeat, what do you do when you get a preliminary injunction? One thing that's actually unique is that the defendant need only win on one of the 4 elements. So for plaintiff has to be able to establish each of those elements. Defendant can show that the public interest is harmed, is not beneficial. It doesn't matter if you can win on the merits or irreparable harm or you have the balance of equity. So that's another thing. And defendants don't like to say that. We want to be able to we attack all 4 elements, but a court need only find that one was not present. Another thing is you want to be able to show that there are options other than injunction to address the harms. So, Your Honor, they want to injunct extraordinary remedy, but here's another way you can address the relief that's available that's short of an injunction. And then, of course, say they may be right, but I'm going to be more harmed. If I can't hire this employee and I have a big project, I'm going to be more harmed than their loss of this potential employee. But you can do all of that and still lose. So what happens when that occurs? One, you can try to narrow the scope of any injunctive relief, whether by time or other limits, to basically not have the breadth that the plaintiff requested. And then one thing, I often see this when there's an injunction issue, there's great news coverage. No one mentions that there's a stay or there's an appeal. And appellate courts' opinions are rarely covered with the same zeal. And a good example, I've actually looked at two recent examples. The DC Circuit just yesterday, they overturned a district court injunction that required Department of State to resume payments, about $4 billion from the USAID and $6 billion for HIV and AIDS programs that Congress had appropriated. And one of the issues, a 2-1 opinion, was that the record was unclear about irreparable harm. Right? Folks said, if we don't get this money, we'll be out of business. It wasn't clear that they were actually out of business, right? So that's another example. And again, just this past Tuesday, the Fourth Circuit overturned an injunction that was issued to a group of labor unions that are blocking the DOGE, the Department of Government Efficiency, from accessing potentially sensitive American user data that several government agencies had. Again, in that instance, the court ruled that the district court had miscalculated the plaintiff's likelihood of success in the merits. There is some coverage there, but I guarantee you, if you compare the coverage on the initial opinion, district court opinion, compared to the appeals, there much more coverage on the former. So a couple of practice pointers before I turn over to Judge Kearney for reporters. Just because an injunction is issued, it doesn't mean that it will stick. You know, the initial injunction often drives the headlines, but boy, there's a lot more that goes. In fact, we often have to say that with clients. The clients, you know, like, we won. They're like, yeah, we won, but there's an appeal. And even if it stays, we have an entire case to go through. That's not the end of it. The declarations that are filed with the injunctions often drive the headlines. But again, they're often one-sided and untested. So defendants really don't have the opportunity to cross-examine. So they should be treated not as proven facts that were admissible and subject to cross-examination. And then finally, the reversal of an injunction is not a commentary about the underlying merits of the case. You can have the best case in the world, but you know, if you don't meet those other elements, even if there is harm, it's not enough. But you know, for many of you, probably the most important perspective to hear how our sitting district court judge looks at injunctions, what the calculus looks like in terms of determining whether one should be issued and the different elements. So I want to turn to Judge Kearney to give some insight onto that.
Thanks, Sozi. I'd like to remind the reporters of something. The judges and our law clerks are trained to write like reporters. And I don't know if you know that. So the way we are trained is that we are trained to write facts, okay, and take out the adjectives as best we can. Lawyers are trained the other way, okay? So I was trained 25 years, and I don't know if I wrote a sentence that didn't have an adjective in it. Okay, sure I did. But judges, like reporters, have to get to the facts. And the problem that the injunctions bring is it's so laden with rhetoric because frankly, it's written as bait to you in many cases. A little bit of history. I grew up as a clerk for the Court of Chancery in the 80s. And in that court then, all we did was TROs, a preliminary injunction to stop mergers and acquisitions. That's all we did. Cases that, you know, somebody's trying to poison pill and tender offers, all the stuff that you remember from a long time ago. And every time we entered an order, it stopped the transaction. So we became, I was trained from the Chancery Court to be very careful. What the professor and Sozi are talking about now is a different world. In the commercial transaction world, in Chancery, for example, if you're commenting on business transactions being challenged, a couple years ago, Mr. Musk's employment contract or whatever it was, compensation. If you're looking at that, that's a different fact than if you're looking at what somebody's rights are under the Constitution. And those of you who should know this, that don't have a background in this, the Constitution is written as aspirational. Just think about it. It doesn't tell us other than essentially Article 3 that tells us specifics and some articles that give us specifics, it's largely written aspirationally. So it's intended to give us wiggle room, all of us as a society, to grow. The lawyer's problem is they try to write it, some injunctions like aspirations. And my advice to reporters is, please understand that we're trying to get at the facts. And I want to tell you something. Judges, at least in the last 11 years since my training, have been trained to try to write their opinions so that the first 2 paragraphs, the first 250 words or so, tell the world exactly what happened in a fact basis. Now, I grew up in law school, and I'm sure the professor and Sozi did too. We read some of these opinions, had no idea what happened to page 26. Okay, that was not very helpful to the public. When I was going through baby judge school, I sat with the Justice Scalia, and Justice Scalia asked about my children. I said, I have a 7-year-old daughter, a 7th grade daughter then. And he turned to the whole room, 50 judges. He said, everybody, pay attention to me. Pull up my daughter's picture. He said, I want you all to write to 7th grader Mary. And I want you to think about that. Isn't that what reporters in many ways have to do? And so lawyers, you have to be very careful about the facts. Judges, when we see them, look, we're used to rhetoric. We just look right by the rhetoric. In all fairness to Sozi and his talented lawyers, declarations are rarely helpful, okay? Because I can almost pick out what they're going to say, okay? What I'm looking for is fact, 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 all the time. The reason that's so important is because people are trying to get momentum. That's what injunctions are about. People, you run into court, you get momentum, the other side may not even know what's happening, and we put the brakes on and say, at least in federal court, we say, hey, wait a second, get the other side in here, I'm not even talking to you. I had cases like David as well, where I'd walk into state court, knock on the door and see a judge half an hour later. That has not happened here in a long time.
Okay.
And so I want you as reporters to understand that it's hard to track it though. It's hard to know what's coming in. I don't know it's an injunction until I read the papers. I don't know how you would know that because they don't advertise it. And so when you see it coming in, realize the judge is looking at facts. He or she is looking at what is going in right ahead, right up front, that are facts. So clear, TROs are very hard to get, folks, because typically we can hold things unless here's the problem with TROs. Good lawyers time them so they create imminent harm. Judges know that. And so we're like, well, sir, you're a little late, Ace. This problem's been raised for 3 months and you're coming on the 89th day. Okay, so I'll give you a stay till tomorrow. So understand that temporary restraining order, hard to get. Second thing is, Sozi mentioned about dollars and the professor did, economic harm, that doesn't count. If the other side can make it up in money, it doesn't count. It's just, and so many cases, guys, come in and say, Your Honor, I need to have this done or else I'm going to lose $1 billion. Well, so you lose $1 billion and you collect it somewhere else. That's what a lawsuit's about. Those lawsuits take a long time. I get it. They take in our court, where the Eastern District of Pennsylvania is now the fastest district court from filing to resolution in the country. But it typically takes from about 9 to 12 months to get a resolution in your non-patent cases and your non-patent disputes. So we have constitutional issues that come in, they're heard, and they're addressed. To Sozi's point, ladies and gentlemen out there, be careful. TROs and temporary restraining or preliminary injunctions don't often end up in a courtroom right away because, as the professor pointed out, they're in chambers. So we're looking for something without lawyers present as to what's involved in it. Also, last point on that. There's a significant case that came out recently that says the sine qua non, the most important factor that we're looking at in these emergencies is irreparable harm. Okay? If it looks like I can stay it for 2 days and have people talk, I'm most likely going to do that if there's a real problem. But if the problem is something that's going to happen 10 days from now, I appreciate your alerting it to us, but it's hard to get temporary restraining order because that's essentially right now. And so be careful about it. Defense knows that, and the press should pick that up. I appreciate some momentum gatherer. I appreciate some momentum gatherer for the lawyers. And the reversal doesn't get published as well. The problem is that it's a long battle, oftentimes, in constitutional issues, executive orders, these kind of issues. The judge is focusing on facts. I've had executive order cases, and the question comes, okay, who is this affecting? I think a little later we'll talk about this, but realize most people coming in for these injunctions don't really have harm themselves. Courts are not political, political platforms. You don't come in and say, I want to stop this. I want to stop this. Why? How are you? Just yesterday, I had an injunction. Judge, I want to stop this because it's not fair. But yeah, I get it. It's not fair. You may not be able to get a bus on Thursday. I understand that. But how are you harmed? I mean, how are you harmed that somebody down the street may not get a bus? And so judges are looking at a whole variety of issues that come in the door. In federal court, you have to have either a federal question, which means constitutional question generally or statutory question, or parties of different citizenship. And so Sozi's absolutely right. Much of what you're seeing is in state court, and there's so many going on, it's hard to follow. In federal court, it's going to be more significant, typically because you're dealing with constitutional issues. I'm happy to address any of the questions on it, but I think what's most important from the judge's perspective is to look at what the judge says in the opinion. And the other thing, I'm going to give all inside baseball on something here. Lawyers do this much worse than reporters. So I give reporters credit for this. Sozi, Sozi knows from his days in the city. We're something called electronic case filing. And on electronic case filing, somebody types in what the order says. Okay? That is not the judge. Okay? I am not typing on my computer for what the order says. My order speaks for itself. And the order is attached. I don't know how many lawyers will read the ECF notice and think, oh, this is what happened, and don't read the order. Reporters, please read the order. I tell first-year lawyers this, but I tell reporters, please read the order, because the order is, especially in an injunction. In fact, be very candid with you, we're required to make findings. We just can't say denied or granted. We have to make findings for the point that the professor pointed out, Sozi, that you can turn around 20 minutes later and be in the Court of Appeals with my injunction. So I'm supposed to explain to the world, 350 million citizens, and to the parties why I enjoin that. So please be careful. Read the order. Don't read the computer. And please don't read the lawyer's press release. Read the order, because the order is going to tell you what happened. And particularly what's happening next.
And just the point about the press release is actually is funny because most sophisticated counsel work with either in-house or external press relations, so that before the attorney even or before the reporter even gets to the opinion, it's been characterized one way or another.
Yeah.
One thing I want to turn to, and just for the record, whenever Judge Kearney is saying all the bad things lawyers do, it's not me. When he's saying all the great things lawyers do in court, he's clearly talking about my appearances before him. One issue that I want to make sure we cover, unless Debbie has any questions, is nationwide injunctions. Now, if you're a casual reader of the news, you say, well, they've been banned. They're no longer allowed. And, they're used against both sides, and the Supreme Court has put a stop to it. If you're also a casual reader of news, you notice that there have been at least 3 and maybe 4 as recently as last Thursday, instances where district courts have issued injunctions with nationwide reach. So Professor Sonenshein, can you explain, nationwide injunctions, alive, dead, or somewhere in the middle?
Well, I remember when the opinion came out, it was in the end of June. In the Supreme Court case, Trump versus Kaza, and it was a case brought by, I guess it's a little unclear because the court isn't clear on it, I must say, by people in the state of Washington, New Jersey, California, Massachusetts, and apparently somewhere in the Fourth Circuit, though it's not told where. It might have been Maryland, because the Fourth Circuit had an order that was involved in this case. All asking the same thing, and that was to enjoin the executive order that created exceptions to the Nationality Act of 1980, which says, as the Constitution does in the 14th Amendment, it's a very simple sentence that's being interpreted. I'll just read it to you. any person born in the United States subject to the jurisdiction thereof is a citizen. It's 8 words or something. And what we have is, I remember the news reports, as Sozi says, I said, oh my God, you mean, you mean? And I started putting ... And the answer is no. If you read the opinion, they were very clear. They effectively signaled to lawyers and litigants, you can do this, but another way. And the other way, and Sozi and I were talking about this last week, 2 weeks ago, and we're getting ready with a class action. And then the cases Sozi just referred to, there's one from New Hampshire I just saw the other day, where the judge said, you can have a nationwide injunction effectively by making the class everybody in the United States who would be harmed by this, because they all share essentially, for these purposes, all of the precisely the same characteristics. That is, people who would not come within the exception the executive order creates. And so it's interesting. I mean, it's what's remarkable to me, if you read the opinion, it essentially invites it. It invites the use of class action. Now, that doesn't mean the injunctions will be granted via the class action device. It doesn't mean it will be affirmed if they do. Class action practice is very complicated and can be very lengthy, et cetera. But I'm a little reminded, I remember when in New York, when P. Diddy, I've forgotten his real name, but when P. Diddy's case was resolved, everybody would ask me, how did he get off? He got off. I said, he didn't get off. He got off on 1 or 2 counts. He was convicted of very serious stuff. And at sentencing, his entire record of his life is before the judge. My personal feeling is he's going to be hit very hard. But that, you would not understand that from reading the quick stuff you see in the newspaper. And everybody I talk to, non-lawyers, a few lawyers too, I must confess, said, geez, he got off. I can't believe that, et cetera. And in point of fact, he didn't. He didn't. And so I think you're the same feeling in this opinion, which is, well, I guess those executive orders can't be challenged anymore. That's not true. That's not true. There is another vehicle. And in fact, a bunch of them were filed almost immediately, as Sozi pointed out. And district judges, I think in New Hampshire, a one-page opinion, 1-page order said, yeah, likelihood of success on this is very good. And the Supreme Court, I will say again, in the Kaza case, the big case that they decided, said what we are not deciding today is the merits of the executive order. That is not before us, and we are not deciding it. And again, I think people miss that in the coverage, which often is too brief. It's a headline, whatever it is. And I think that Sozi's point about, and the judge's point, read those first 2 paragraphs and get the full story. And so that the headline, for example, not necessarily your fault, and many of you don't write the headlines. But the fact is, they may not give the entire story.
Professor Sonenshein, to that point, the way, and there may be folks in here who can amplify this, the way that we consume news, I assume, is different. And I cheated by citing in the beginning the traditional papers, Inquirer, Times, Post, and Wall Street Journal. The way many people consume news is by looking at a Twitter feed or seeing something, a ticker at the bottom. And oftentimes it would be nationwide injunctions banned, or a preliminary injunction issued, and no one, very fewer people than before go into, let alone non-lawyers, go into and say, oh, how did they get element 3? I'm very surprised by that, right? So we have mentioned headlines, not to do it sort of in a very glib way, but to really appreciate that the way news is consumed by, I would say, the majority. The way my kids consume news is very different than the way I consume news, that the headline really does drive a lot of narrative. And so that's why when I asked about nationwide injunctions, because people were like, I don't understand, either they're banned or they're not. And then the other point about Route 23, which is the rule of procedure that drives class certification, it's a pretty long-standing rule. Judge Kearney and district court judges are very familiar with them. They're sophisticated counsel who do so to lawyers. This is not new, right? There are ways you try to define a class, you try to make sure the scope is within reach. But to non-lawyers, it's often a different, perhaps a different procedural and separate vehicle that folks aren't familiar with.
Sozi, I'm going to interrupt you for a second. It may be a different procedural vehicle. Also, it lengthens the process, right? I mean, I used to do class action litigation. This is validating it. It's great for class action lawyers, but it's a lengthy process, and preliminary injunctions time is of the essence.
Yeah.
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 But it goes back to the point.
Yeah, Sozi, I'd like to jump in on that because the problem with class actions is also, to those of you who know, these are decisions made as to one person. They're not making a class decision yet. So I want the reporters to understand something. What's going to happen, in my view, I can't predict everything, but there's something called declarations. So you should be careful when you see cases. What we're seeing more and more is lawyers bringing cases asking for what we call a declaratory judgment as to their client alone. Okay? So Mr. Smith has a claim that he should not be deported. All right. When Mr. Smith, when a district judge resolves that issue, we have something called precedent. And my colleagues around the country and I will all look at what other judges have done. It has some influence. So we don't need this idea. Nationwide injunction is such a weird term. It's not really used by anybody. Universal injunction, it's not really what that is. Somebody talked about shadow dockets and that's not what that is. What's really happening is typically you see a declaration as to one person and people try to expand it. So I think that's what you want to be careful about.
Yeah.
Yeah.
Can I make a
Thank
point,
you.
Judge Kearney? It just reminded me of something. As I understand it, in the 4 or 5 cases that were joined together in the Supreme Court decision, the court stayed only, Supreme Court, the nationwide aspect of the injunctions. Those injunctions remain in place in California, in Massachusetts, in New York, et cetera, et cetera. So the people in those states, the plaintiffs are protected temporarily at the moment by those injunctions.
So this class is a nice idea, folks, when you're reporting about it. The class idea mechanism, it's a nice idea. It takes a long time, but also it doesn't really get you the relief in the long run that you think you're gonna get right away. I mean, in the long run it may, but if you need to do something by Thursday, that's awful hard to do in that context.
Yeah, I think, Debbie, what's our time check? So I know where.
You have 8 more minutes.
8 more minutes. Okay, we'll try to squeeze 9 if possible.
No, you can. Go ahead.
Well, let's think about some ways, some practical tips, and we've peppered our comments with some of those. But I want to start off with the judiciary, because you can't interview Judge Kearney about his opinion, and he writes a long memorandum, he issues his order, because that's how judges speak. Judges can't go back and forth. But the federal judiciary in particular, and you're seeing this with state courts, are cognizant of the fact that there needs to be more robust effort to help journalists do the job. So, and I'll try to get the link, but the Administrative Office of Courts has something called a Journalist Guide to Federal Courts. Now, for you, many of you seasoned reporters, this is, you know all of this, but for people starting out, understanding the idea of interlocutory appeal, that you can appeal something before the case is over, understanding some of the things that we had discussed here is something that, we want to urge all of you just to look at, because there is a more concerted effort. I wouldn't say district courts with budgets always at risk have somebody full time to talk to reporters. That's not the case. But there is, at least at a centralized level, some effort to do that. But some of the things that we had discussed before are verify, look closely at the claims and declarations. Sometimes they have exhibits, prior filings. Understand that judges ultimately are there to represent a party, right? And that's our ethical obligation. So take that into account when you're talking to a litigant or an advocate. And obviously, don't stop at the initial rulings. I've had preliminary injunctions where when you get the permanent injunction, that's later on, no one's of interest. So I said, didn't you already get that? It's already, again, even with clients, said, I said, look, you still have to pay my bill because I'm still working on it. I can't, the case has not stopped. And the reason I emphasize that, because even among sophisticated counsel, sophisticated parties, there's that sense that the original victory is the end of the case. In some cases, that might be true, but oftentimes what we see, it actually gives you leverage. If a plaintiff is able to get a PI, then as a defendant, like, let's try to figure out a way to resolve it. If a PI is denied, then that signals to the plaintiff, like, it's gonna be very expensive and long to get to the merits. So I wanted to turn Judge Kearney and Professor Sonenshein on some practical views in the last 5 minutes for our reporters.
Let me take one quickly, and then Professor, I'll turn to you, Dan. Realize that in the chambers, these things come in quickly, and we're working on tight deadlines. And so I tease the Supreme, I don't tease them directly, but we always laugh about the Supreme Court's decisions and back and forth the last couple of months about district courts being like Denny's, open. Are district courts supposed to be open 24/7? Are we supposed to rule at 1 o'clock in the morning and stop something at 7? Colleagues have taken different views of that, let me just say. But the point is this: we are moving on a very expedited path in a lot of these cases. And so as you're reporting it, be mindful of that. Just like when you're on a deadline and you have to do something in half an hour, you have to sort of get to the wheat and try to get the best you can. In many of our cases, we're trying that as well. In federal court, typically we give the reasoning. In state court, and I certainly may correct you on this, you can issue an opinion or issue an order, and then later ask the judge to write an opinion, at least in Pennsylvania, write an opinion later about what the reasons for the state court's view was. In federal court, we generally give you our reasons. But the point is, we're going to say it as best we can, and then hopefully you'll see more. So my biggest tip coming out of this is recognize this is all on an expedited basis. It is a snapshot, but not the full snapshot. It is a piece of the puzzle, not the entire puzzle.
And they're also often, I won't say notorious, they're legal situations where the injunction request is filed at 4:59 on Friday afternoon.
Right.
People have already gone to the beach or they've gone wherever. And sometimes the clerk, I know this happened in state court in Massachusetts, might close 10 minutes early. And all of a sudden there you are. So the pressure on the lawyers and on the judges and their clerks can be enormous, which can sometimes happen when that kind of thing happens. And everybody's, I think, had that experience who's been in practice. We get these things very late in the day, and there's little you can do.
Yeah, and I think one thing that we all agree on is that in one of the core components, particularly in a democracy like ours, in the effective administration of justice, is having reporters understand the way the court system functions, because oftentimes the public is not going to have ready access to that, and so they rely on your ability to understand, your ability to communicate, and many times they make decisions and form impressions, whether politically, economically, based on how you were able to articulate what is happening. And preliminary injunctions is one example.
Remember, reporters, we can only answer the question that is asked to us. We're not legislators. We can't just comment generally on policy. If somebody comes in and asks us, is today Tuesday? My answer is yes or no. It's not what's the benefit of Tuesday. So I think the world at large thinks, why isn't the judge addressing this? Why isn't the judge addressing more executive orders? Why isn't the judge addressing the both sides issues? Why is he stopping this? Is she stopping this conduct? It's not our job. Our job is to answer the question under Article 3, the constraints given to us. Answer the question given to us, not be creating public policy that way. Interesting perspective for reporters.
Yeah. We're right on time, right, Debbie?
Yes, you are. I mean, I think as a follow-up, your timing was great because, judges aren't litigators, right? Judges are neutral. Judges are independent. Judges don't create the issue. Judges address the issue that's presented to them. So I know that the reporters often get frustrated with the court, I'm going to say, but they really do have a lot of constraints put on them. And I think that'll help you understand how and why opinions are issued as they are. Sozi, David, Your Honor, do you have anything else to add?
Thank you.
Okay, thank you
Thank you
very
so
much.
much.
I truly appreciate it. Sozi put in the chat the federal court's guide for journalists. I will also, PMC will also be sending it around afterwards. So thank you all. And we are going to turn to our next panel about understanding what the media and press can and cannot do inside the courtroom and its environment. So give us a little time to bring up our next panel. Thank you very much.
Thank you.
Thank
Appreciate
you.
the time.
Thank you.
All right. Bye.